Many married taxpayers file joint tax returns because of the financial advantages this filing status allows them. However, when married taxpayers file jointly, both taxpayers are jointly as well as individually responsible for the taxes and any interest or penalty due on the joint return, even if they later divorce. For example, if a stay-at-home spouse filed joint tax returns during the marriage while the moneyed spouse underreported his or her income or made fraudulent claims, both parties may be liable for all the taxes, interest, and penalties in connection with these joint returns. This is true even if a divorce decree or judgment states that one of the spouses will be responsible for any amounts due on the previously filed income tax returns. Further, one spouse may be held responsible for all of the taxes, interest, and penalties, even if all the income was earned by the other spouse. Therefore, filing a joint return during the marriage or after separation presents spouses with risks that they must consider and protect themselves against. The Internal Revenue Code offers possible remedies for spouses who find themselves in the position of defending an improper or erroneous tax return, which is referred to as innocent spouse relief. By requesting innocent spouse relief, a joint taxpayer could be relieved of the responsibility for paying tax, interest, and penalties if their spouse has improperly reported or omitted items on their joint tax return. Generally, the tax, interest, and penalties that qualify for relief may only be collected from the spouse or the former spouse for misreporting. To qualify for innocent spouse relief, a taxpayer must meet certain fairly strict requirements under the Internal Revenue Code. If they do meet the requirements, they could qualify for the status without being held responsible for paying the taxes, penalties, and interest.